Tonight, we begin with a development that immigration attorneys, travel experts, and federal officials had feared, dismissed, and quietly tracked for months. A move that unfolded not over years of debate, but in a single congressional session, a single bill introduced on a single December morning, a single bill that could strip millions of Americans of a right they never thought was in question, a single bill that could force dual citizens to choose their American passport or everything else. A single bill that could upend the lives of nearly 10 million people without warning. What lawmakers in Washington did in late 2025 crossed a line that constitutional scholars and immigration advocates had hoped would hold. And when that line was tested, America's legal community did not hesitate. They responded with outrage, urgency, and a clarity of purpose that you rarely see in modern immigration policy. Tonight, we break down everything you need to know, because if you hold two passports, this story is about you. For years now, there had been signals, not from official State Department bulletins, not from formal policy changes, just signals that certain legislators in Washington were preparing something that could fundamentally alter the relationship between the United States government and its dual citizens. The United States has been notably permissive about dual nationality, yes, but it has been quietly watching in its permissiveness. Washington's stance on dual citizenship has followed a certain pattern, a pattern of tolerance, almost a gentleman's agreement, in which the government does not require you to choose, so long as you play by the rules. But what set off alarm bells in immigration circles this past winter was that the pattern went silent. Experts who monitor citizenship legislation know the indicators. The quiet introduction of loyalty-framing bills in committee. The renewed use of the phrase sole and exclusive allegiance in congressional language. The rising political rhetoric around national identity and foreign influence. The sudden, coordinated framing of dual citizenship as a security risk. All of that went quiet, and then came roaring back at once. And whenever Washington goes quiet on a sensitive immigration issue, it means something is about to get loud. On December 1st, 2025, it got very loud indeed. Early in December 2025, legislative watchers detected what they described as an aggressive new citizenship proposal, including specific statutory language that had not been introduced in Congress in over a generation. Senator Bernie Moreno, a Republican from Ohio, introduced Senate Bill 3283, officially titled the Exclusive Citizenship Act of 2025. These are the kinds of legislative moves that lawmakers only make when they are signaling something very specific: a demand for absolute national loyalty, a political realignment on immigration, or the beginning of what could be the most sweeping change to citizenship law in American history. Legal observers didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that Washington was changing its posture on dual citizenship. And when the federal government shifts its stance on citizenship, even by a single bill, even in committee, immigration attorneys, tax advisors, and the 20 million Americans estimated to hold dual nationality pay very close attention. Because the text of this bill was not subtle. The Exclusive Citizenship Act stated plainly that it would prohibit any American from simultaneously possessing any foreign citizenship. It demanded what the bill calls sole and exclusive allegiance to the United States. In plain English, one country, one passport, no exceptions. The response issued by the legal and immigration community was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney, analyst after analyst, described Senator Moreno's move as constitutionally dangerous, logistically unworkable, and perhaps most importantly, deeply personal, affecting real families, real careers, and real lives that had been legally built across borders. But a legislative threat only works if its targets remain unaware. Millions of Americans were not. In fact, the public response was among the most intense we have seen to a citizenship bill in a generation. Within weeks of the bill's introduction, immigration law firms across the country reported a surge in consultations. These weren't routine questions about green cards or naturalization. These were emergency strategy sessions from dual citizens who wanted to know, am I at risk? Do I need to act now? What happens to my children? The bill's scope was extraordinary. It did not just target new dual citizens. It reached back and demanded that existing dual citizens, people who had legally held two nationalities for decades, make a forced choice within 1 year of enactment. Keep your U.S. citizenship and formally renounce your foreign nationality, or keep your foreign citizenship and automatically lose your American one. No grandfather clause, no exceptions for those who acquired dual nationality by birth, no grace period beyond 12 months. Tonight, let's confirm what the Exclusive Citizenship Act would actually do, because the details matter enormously. The bill targets 3 distinct groups. Group 1, existing dual citizens. Anyone currently holding U.S. citizenship alongside another foreign nationality would have 1 year from the date of enactment to submit a written renunciation, either renouncing the foreign citizenship to the Secretary of State or renouncing U.S. citizenship to the Secretary of Homeland Security. Fail to do so within that window? Under the bill's text, you would be deemed to have voluntarily relinquished U.S. citizenship, not by your own choice, by inaction in a bureaucratic system. Group 2, future naturalizers. Any U.S. citizen who voluntarily acquires a foreign citizenship after the law's effective date would be treated as having automatically relinquished their American nationality. The moment you are naturalized abroad, you are no longer American. Immediately. Group 3, the families left in the middle. This is the category that keeps immigration attorneys awake at night. Households where one parent is foreign-born. Children who inherited dual nationality by birth. Families who cross borders regularly for school, work, and caregiving, all now potentially facing a legal status in limbo. They hit the established dual citizens. They hit the future naturalizers. They hit the families who had never imagined their legal status was in question. In other words, the bill targeted the full infrastructure of dual nationality in America, the paperwork that makes it legal, the tradition that makes it normal, and the expectation of millions of Americans that their citizenship was permanent, not conditional. This is what made the legal community's warning so urgent. The Exclusive Citizenship Act wasn't just symbolic legislation, it was actionable. It represented the kind of structural change that could reshape the American identity itself if left unchecked. And here's where the story becomes even more complex. Legal scholars now believe that Senator Moreno's bill was designed to test the political appetite for a harder line on national loyalty, to probe the tolerance of the American public for restricting what had long been considered a private legal matter. The bill's sponsors wanted to see whether Americans would push back. But instead, the opposite happened. The legal community didn't stay quiet. Immigration attorneys, speaking with major media outlets under their own names, described the bill's automatic relinquishment provisions as constitutionally indefensible, a direct collision with Supreme Court precedent that has long recognized the right of individuals to hold dual nationality. You don't easily get constitutional lawyers to agree on anything, But today, the opposition to this bill was remarkably unified. One analyst described the bill's one-year forced choice window as administratively impossible, pointing out that the State Department's consular system simply cannot process the millions of renunciation cases the bill would generate. The infrastructure does not exist. The staffing does not exist. The funding was not even requested in the State Department's 2026 budget. But here is the deeper layer that matters most. Under current U.S. law, the law that exists today, before any bill passes, dual citizens already face a requirement that many of them may not fully understand. The U.S. Customs and Border Protection and the State Department are both clear. All U.S. citizens, including dual nationals, must use their U.S. passport to enter and exit the United States. This is not optional. This is not a suggestion. This is federal law. That rule, that existing enforceable rule, is the real story that millions of dual citizens need to hear right now. Because high-profile cases of denial of boarding and denial of re-entry have already occurred. Real travelers, real consequences, all because they attempted to enter the United States on a foreign passport instead of their American one. That element matters because it shows something important. The rules surrounding dual nationality are already stricter than most dual citizens realize. The Exclusive Citizenship Act, if it passes, would make them incomparably stricter. But even without the bill, there are rules in place right now that are being enforced, and that enforcement is intensifying. As reports have continued coming in throughout 2026, we have learned more about the scale of this issue. Customs and Border Protection has already enforced the U.S. passport-only entry rule with increasing visibility, with multiple high-profile incidents of dual nationals being denied boarding or stopped at ports of entry for presenting foreign travel documents. Airlines and international carriers that operate routes into the United States have begun tightening pre-departure document checks, forcing passengers to demonstrate valid U.S. passports before they are allowed to board flights bound for American airports. The Senate Judiciary Committee, which received the Exclusive Citizenship Act for review, has not yet scheduled a vote. And legislative forecasting models put its probability of enactment at approximately 3%. But the mere introduction of the bill has already altered behavior. This wasn't just a political debate. This wasn't just a headline. This was a warning shot that reverberated through embassies, law offices, tax advisory firms, and family dinner tables from Los Angeles to London to Lagos. And the one thing that dual citizens have struggled to maintain throughout, clarity about their own legal standing, has never been harder to hold on to. Remember, for decades, the assumption was that America's approach to dual nationality was settled law. Lawmakers thought the issue was too personal, too complex, and too constitutionally tangled to ever become a genuine legislative target. They thought the millions of Americans who had built lives across two countries were safely beyond the reach of loyalty-based restrictions. They thought the era of forcing citizens to choose between national identities had passed with the 20th century. But tonight, the exact opposite is unfolding. A sitting U.S. senator has introduced a bill demanding exactly that choice. Federal agencies have been tasked in the bill's language with tracking compliance and reclassifying non-compliant dual citizens as non-Americans. And millions of people who thought their citizenship was permanent are now consulting attorneys to understand their options. The landscape has shifted, and whether or not the Exclusive Citizenship Act ever becomes law, the conversation it has started cannot be unstarted. What makes this moment so consequential and so unsettling is that the bill arrived at a time when American immigration policy is under enormous pressure from every direction. National security hawks want stricter loyalty requirements and a harder line on foreign allegiances. Immigrant communities and their advocates want protection for naturalized Americans who legally hold the citizenship of their birth countries. Constitutional scholars want the courts to weigh in on whether Congress can even strip citizenship without a clear voluntary act. And ordinary families, the 20 million estimated dual citizens, want to know if the passports they carry, the lives they've built, and the countries they love are now officially in conflict. The State Department's existing travel guidance, now circulating widely across dual citizenship communities, was designed to signal that the U.S. government is not willing to allow ambiguity to serve as an excuse for noncompliance. Officials at the State Department and Customs and Border Protection have said plainly that attempting to enter the United States on a foreign passport as a U.S. citizen is inconsistent with U.S. law and subject to enforcement action. That is measured bureaucratic language for, "We will stop you at the border, and you may be denied entry to your own country." You don't usually hear that level of enforcement language applied to American citizens, unless something serious is already happening at the ports of entry. And according to the reports coming in from 2026, something serious is. Meanwhile, immigration attorneys across the country have addressed their clients in urgent consultations that sound less like routine legal appointments and more like emergency briefings. They are saying, do not travel internationally without your valid U.S. passport. They are saying, if your U.S. passport is expired, renew it before you leave, not after. And they are saying, monitor this legislation, not because it is likely to pass, but because even its proposal has consequences for your planning, your tax compliance, and your family's legal stability. These are not rhetorical cautions. These are statements from professionals who understand just how high the stakes have become. Here's what makes the situation even more layered. The passport rule enforcement isn't isolated. Along with the exclusive Citizenship Act debate, the Supreme Court is simultaneously reviewing Executive Order 14160 on birthright citizenship, with implications for how allegiance is defined legally in the modern United States. European travel systems, including the forthcoming ETIAS authorization requirement launching in late 2026, are tightening border data collection for all travelers, including dual nationals. IRS enforcement of foreign bank account reporting and worldwide income disclosure for U.S. dual citizens living abroad has intensified, with penalties for non-compliance reaching into the tens of thousands of dollars. All of this happened within the same 12-month window. When the government moves multiple legal instruments at once affecting dual citizens, passport rules, citizenship legislation, tax enforcement, and border screening, it means something larger is underway. A fundamental renegotiation of what it means to belong to more than one country. Legal analysts are now considering several possibilities. One is that the Exclusive Citizenship Act is preparing the ground for a broader legislative push on immigration loyalty requirements that will gather momentum in the next Congress. Another is that the bill is a political signal, an attempt to reshape public conversation about national allegiance without necessarily expecting the law to pass in its current form. A third possibility, the one worrying legal experts and immigrant communities most, is that the bill's automatic relinquishment clause is a test case. legislation intentionally designed to face a constitutional challenge that could produce a Supreme Court ruling clarifying once and for all how far Congress can go in restricting dual nationality. But today, one thing is clear. Dual citizens cannot afford to be passive observers in this debate. Those who act, who renew their U.S. passports, document their citizenship status, consult legal and tax professionals, and monitor the bill's progress, are positioning themselves for any outcome. Those who don't may find themselves on the wrong side of an enforcement action they never saw coming. What we are watching now is a test of American identity itself. Washington wants to see whether the public will accept a harder definition of national loyalty. One country, one passport, one allegiance. Dual citizens want to demonstrate that belonging to more than one nation is not a betrayal. It is a reality for millions of families built across borders. Constitutional lawyers want to prevent a statutory stripping of citizenship rights without clear voluntary intent. And ordinary Americans want to prevent the creation of a two-tiered system in which legal status becomes uncertain. Families are split by bureaucratic deadlines, and a passport becomes a loyalty test rather than a travel document. Tonight, we have heard from immigration attorneys and policy analysts who are now actively monitoring the Exclusive Citizenship Act's progress in committee. They say the bill has not moved beyond introduction, and current legislative forecasting gives it approximately a 3% chance of enactment. They say the State Department has made no changes to its existing dual nationality guidance, meaning today, right now, dual citizenship remains fully legal in the United States. And they say that Senator Moreno's decision to frame the legislation around loyalty and allegiance is likely part of a broader political strategy intended to shift the conversation on immigration over time. But dual citizens are not waiting passively for an outcome. In fact, dual citizens are taking action, renewing U.S. passports, consulting immigration and tax attorneys, taking documentation inventories, and building contingency plans. Their response, informed, strategic, and calm, sent a message to Washington that this community understands the rules, is watching the legislation closely, and will not be caught off guard. As the months ahead unfold, we expect more details to emerge about what the Exclusive Citizenship Act's sponsors ultimately hope to achieve, and whether the legislation will gather the political momentum it needs to move beyond committee. But what we do know is that this moment, this public debate, this legal scrutiny, this enforcement spotlight, arrived at exactly the right time. It has forced millions of dual citizens to understand their existing obligations under U.S. law. It has clarified that the U.S. passport-only entry requirement is not a technicality. It is a federally enforced statutory obligation. And it has created an opening for a genuine national conversation about what citizenship means in a world where more people than ever belong to more than one place. And tonight, for the first time in a generation, the question of dual citizenship in America appears to be genuinely unsettled. Washington is watching, the courts are watching, and 20 million dual citizens are watching. Too much is on the table. Too much is at stake. And when governments begin moving the boundaries of citizenship, even through proposals that seem unlikely to pass, it means they are testing the ground beneath your feet. Because tonight, dual citizens learned something that bears repeating. Your passport is your most powerful travel document. Use the right one. Your citizenship is your most protected legal status, but only if you understand the rules that govern it. And the line between legal and non-compliant can be crossed at a border checkpoint by a document you chose to present, or one you forgot to bring. This story is far from over. But tonight, one thing is clear. The rules around dual citizenship in the United States are being scrutinized as never before. The enforcement of those rules is intensifying right now at ports of entry across the country. And the window to get informed, get compliant, and get prepared is open, but it will not stay open forever. We will be here watching every detail as the next phase unfolds.